time.
Hi, I'm Emily Johnson,
And I'm M. Perizzo.
and today we are going to be presenting on arbitration. The objectives of arbitration is to use a neutral third party called an arbitrator to reach a fair decision. Arbitration is best used to solve a dispute between two parties rather than just a misunderstanding. Arbitration is also used to avoid having to go to court.
So the process of arbitration typically starts with the request for arbitration, which is done usually in writing from one party to the other. The next step is to find an arbitrator, which can be done in a variety of ways. The parties can mutually agree upon a single arbitrator. They can also decide to choose a panel of arbitrators. Typically, this would be an odd number to avoid ties, and would be done in something like each party choosing one arbitrator and then those two deciding on a third arbitrator. There also can be arbitrators chosen by an external third party. The next step would be a preliminary hearing where the issue would be discussed between the two parties and the arbitrator, and they would also organize the process and the time frame that the rest of the steps would be in. Next would be preparation and information exchange, where both parties are able to gather their information and then exchange it between themselves and the arbitrator. Next would be any additional hearings where both parties present their sides to the arbitrator, and the arbitrator is able to get a better understanding of both sides of the issue. Next, if necessary, but it doesn't always happen, would be post-hearing submissions. So if there is any additional information that needs to be presented, or if there's anything that needs to be clarified, that would happen during post-hearing submissions. Lastly, the arbitrator makes their decision and sets the award. These can be made either binding or non-binding, though if they are binding agreements, then that is final, as there is no appeal process for arbitration. Additionally, the arbiter will most likely give their rationale for the decision that they made, so it is not required. And occasionally arbitrators will just state what their decision is and will not give any rationale behind that decision.
So who uses arbitration? There are three main clients of arbitration. There are corporations or companies, consumers, and employees. Depending on who is involved in the case will depend on what type of arbitration takes place. There's commercial arbitration for disputes between two companies. There's consumer arbitration for disputes between a company or a supplier and a consumer or customer. For example, a dissatisfied account holder may request arbitration with their bank. There's labor arbitration, so kind of anything related to employment. If an employee feels that they were improperly terminated, they may request arbitration with their employer. There's grievance arbitration, also known as rights arbitration, it's a type of labor arbitration that involves previously existing collective bargaining agreements. There's interest arbitration or contract arbitration, which is a type of labor arbitration to help solve a deadlock during the process of negotiating contracts. And finally, there's mandatory arbitration. And this is usually between a company and a consumer, or an employer and an employee. It is when there's a clause in their contract stating that the employee or the consumer or the company and the employer will use arbitration instead of the courts. This is usually called an alternative dispute resolution clause. And typically in this situation, the company or employer are usually the ones who choose the arbitrator or arbitrating company and the location where the arbitration actually takes place.
So some pros of arbitration include it being less formal than a traditional court system, but it is more formal than something like mediation. It's also usually a faster process than the court system and tends to be more convenient as the parties themselves can decide things like the time, the date, and the location, which all would traditionally be set by the court itself. There is also the aspect of privacy. In a court system, if you were to have a regular trial, the decisions would be made public, and the public could potentially have the option of viewing the process if they wanted to. In arbitration, it is all completely private and just between the two parties and the arbitrator, and they don't need to make anything public if they don't want to. There's also the aspect of mutual consent, where both parties are agreeing to use arbitration. This can feel like there's not mutual consent in a situation where there's forced arbitration, but in that situation, as previously stated by Emily, there's usually a clause in the contract where both parties have signed saying that they would use arbitration instead of the courts. There's also wider choices, not just in the location and the dates, but also in who is helping to make these decisions. In the court system, you don't really get to choose who your judge is, and you don't really get to choose who your jury is going to be. But in arbitration, you get to choose who that arbiter or panel of arbitrators are going to be. Lastly, there's the option to have a non-binding agreement or a binding agreement, depending on what you're looking for. In the court system, you can pretty much only have a binding agreement, whereas in mediation, you can pretty much only have a non-binding agreement. So this, again, gives you more options to solving your dispute.
So now for the downsides of arbitration. First is cost. Well, typically it is less expensive than traditional litigation. The cost has increased over the years as the demand for arbitration has increased. Also, more complex cases tend to cost more. Second, there's a lack of an appeal process, which means the arbitrator's decision is final if the parties agree to a binding decision. Typically, there are only two grounds for an appeal, and those typically are if there was a clerical error made in the decision, or if gross negligence on the part of the arbitrator or arbitrators can be proven. Third, there may be a lack of sufficient relief for one of the parties, as there's no law structure that the arbitrator is required to follow when awarding relief. And then finally, some contracts that require arbitration as a resolution method may prohibit a consumer's right or an employee's right to litigate, and that includes participating in a class action lawsuit.
So when is arbitration most effective? As we previously stated, arbitration is used to resolve a dispute, and it's typically something that is beyond a misunderstanding. If the parties want the option for a binding agreement, but may want to also have a non-binding agreement, then they would opt for arbitration. As previously stated, the courts would be binding and mediation would be non-binding. This gives somewhat of a middle ground. If the parties don't want to involve the courts, this is usually due to privacy reasons, then they'll probably choose arbitration over the court system. If they want a specialist to help make the decision, they'll probably choose arbitration because the specialist will probably have more specific knowledge than a judge. And lastly, if the parties either are having trouble agreeing on a jurisdiction, or if they disagree with what the court would say is the jurisdiction, they'll probably use arbitration as they can set their location.